Hello, I'm Dr. Ira Nash. Welcome to Well Said. Today, we'll be talking about a question at the intersection of medical care, ethics, and public policy. That is, should doctors be empowered to assist patients with ending their own lives? In New York State, the answer is now in Governor Hochul's hands with the recent passage of the Medical Aid in Dying Act that is awaiting her signature after its passage in the New York State legislature. To talk about the bill, the rationale for its enactment, and the controversy surrounding it, I'm delighted to have on the show an expert and an advocate with a profound personal stake in the outcome, Dr. Jeremy Boal. I've known Dr. Boal personally for over 25 years. We both worked at Mount Sinai Medical Center in the late 1990s when he founded the Mount Sinai Visiting Doctors Program to provide holistic, high-quality care to homebound adults. We crossed paths years later when he and I both joined Northwell Health. Dr. Boal then returned to Mount Sinai in 2013, where he rose to become the Executive Vice President and Chief Clinical Officer, where he oversaw the medical care across Mount Sinai's network. He retired from Mount Sinai in 2023 after being diagnosed with amyotrophic lateral sclerosis, commonly known as ALS or Lou Gehrig's disease. That's a fatal degenerative neurological disease. He has been a powerful and consistent voice in favor of the Medical Aid in Dying Act, and I'm honored to have him join us today for this important conversation. Jeremy, welcome to Well Said.
Ira, it is a genuine pleasure to be with you today.
So, Jeremy, I want to start by asking you the most important question of our conversation, really, which is, how are you doing?
Well, Ira, I love that you're starting with that. And I'm doing really well. I would say in spirit and mind, I'm doing great. In body, I'm doing pretty well, too. I'm speaking to you from our farm up in Columbia County, where I'm busy tending to my goats, chickens, and dogs with my wife and making the most of my early retirement.
Could you tell us a little bit about where you are in your journey with ALS and what your kind of personal prognosis is at this point?
I had my first symptoms when I was actually doing some global health work in Nepal and developed some stiffness in my left leg. That was back in the summer of 2023. By November of 2023, I had been diagnosed with ALS officially. I'm a little under 2 years out from my first symptom, and I would say I'm on the slower end of the spectrum in terms of progression. Typically, most people who develop ALS pass within 3 to 5 years of their initial symptoms. About 20% make it to 5 years, about 10% make it to 10 years, and about 5% make it to 20 years. So I'm 2 years in. I've got a little bit of runway. I'd say a little bit more than a little bit of runway ahead of me.
You know, in my limited experience of dealing with folks who have ALS, one of the things that is an early part of their disability is their ability to speak. You're coming across loud and clear. Is that just luck of the draw? What sort of symptoms do you have right now?
Thank you for asking that. It's luck of the draw. So if you take 100 people who get ALS, 2/3 of those folks will have what they call limb onset. So it'll start in an arm or a leg. And that tends to have a slower progression than the other third, who present with what they call bulbar ALS. And what that means is if you have bulbar ALS, you actually present with your first symptoms are something related to speech or swallowing or breathing. So I'm limb onset, and so far I don't have any bulbar symptoms. But essentially everybody with ALS ultimately develops all of those things. So my course, even though it's slower than some, will ultimately include total body paralysis, loss of speech and swallowing, and ultimately the inability to breathe and death. Yeah.
Well, I wish you the best with that.
I appreciate it. You know, it was quite a blow. As you can imagine, I was perfectly healthy at 56 when I got my diagnosis. You know, my parents are still alive, and one thing I think most people in the public, and maybe even a lot of doctors don't know, is that ALS, in almost all cases, is what they call sporadic. So 9 out of 10 people who get ALS don't have any family history whatsoever.
Yeah.
And that was my case as well.
Yeah. Well, again, best of luck to you with your course, and I hope you're one of the lucky few who has many years ahead.
Thank you. Thank you so much.
So I'd like to start our conversation about the public policy issues with a few definitions. So I said that the New York State legislature just passed a bill called medical aid in dying. What exactly is medical aid or assistance in dying, and is that the same as assisted suicide?
We get asked all the time about that, and also, is it the same as euthanasia?
Yeah, please.
And we can certainly talk about that as well. So a bit of history. So about 3 decades ago in Oregon, a law was passed, a very, very specific law was passed. And what that law included was if you were terminally ill and 2 physicians were able to certify that you were likely to have a remaining life of less than 6 months, you were an adult, you had what they call decisional capacity, so you were competent to make decisions for yourself, you could request and ultimately receive a prescription for life-ending medications that you would have to then, if you chose to use them, you'd have to self-ingest, so nobody could give them to you. That basic framework is what we call medical aid in dying. And after Oregon, a number of other states and Washington, D.C. also enacted virtually identical laws with virtually identical guardrails. What's unique about what we call medical aid in dying is that the only people who are eligible are terminally ill and are very close to the end of life. And so one of the reasons why we don't consider it assisted suicide is because these are people who are dying. And so it's not necessarily shortening their life, it's shortening their dying phase. In almost all cases, when people avail themselves of medical aid in dying, it's really very, very close to when they would have died if they hadn't. But what they're doing is they're able to have some sense of agency and control. Mm-hmm. So that's how we think about medical aid in dying and why we think it's different than what we would call assisted suicide. And euthanasia.
Before you get to euthanasia, I think you mentioned something that I think is important, which is the patient or the person of focus here has to be able to ingest the medication him or herself, right? Nobody's injecting them with anything or giving them anything. They have to have the physical capacity to take whatever it is they've been given. Yeah.
Yes, that's right, Ira. And that's actually a critical safeguard because it essentially alleviates the concern. And now, as we've seen over nearly 30 years, we haven't seen any cases of abuse of this. It alleviates the concern that somebody would do something to a patient against their will.
Okay.
Because really the patient ultimately has to be able to administer the medication to themselves.
Yeah. I interrupted you. You were about to educate us about the difference between this and euthanasia.
Yeah. So euthanasia classically is, described as somebody administering the medications to you. And so, for example, in Canada, where they have, their own legal framework for end-of-life options, when people avail themselves of those options to end their lives early, it's actually in almost all cases a physician that administers the lethal dose, typically an injection. That's classical euthanasia, and it's illegal in all 50 states, including in all the states where medical aid in dying is legal, where people can self-ingest medications if they're terminally ill.
All right, so we're not talking about that here in New York State.
Not even close. In fact, that's a criminal offense.
Okay.
If that were to occur, even after this bill passes.
And so tell us a little bit more about the specifics of this bill that is literally on Governor Hochul's desk, right? I mean, it's passed the legislature. It's up to her to either sign it and turn it into law or veto it.
Correct, yeah, or let it expire unsigned. So the work of trying to get this bill passed started in earnest, I'd say about 10 or 11 years ago when it was first introduced at the Health Committee in the Assembly. And there's been a decade-long effort by advocates and others to convince legislators in both the Assembly and the Senate that this is a humane and compassionate option. As a society, we typically shy away from talking about death and dying, even though, it's the final common pathway for all of us.
Right.
It can be a really uncomfortable thing to talk about and think about. And so it typically takes a long time, for legislators to process this, reflect on it. Maybe they have family experiences that inform their thinking. But in essence, after a 10-year effort, this year, the bill was reintroduced and passed the Assembly and just recently passed the Senate. And it now sits on, as you said, on Governor Hochul's desk. You
ran through some of the provisions of the bill in Oregon that kind of started this movement in the United States. The New York State bill is closely patterned on that?
There's a couple of minor differences that I'll share with you. So what I shared with you about the Oregon bill is identical. A couple of other things to know about the medical aid in dying legislation in New York, and this is true for the legislation in most states, is that if either of the physicians who is certifying that the patient, is an adult and they are able to make decisions for themselves and they have less than 6 months to live, if either one of those physicians thinks that the patient may have a mental health issue that's clouding their judgment, then they're required by law to refer the patient for a mental health evaluation before they can proceed. And so that's an additional safeguard.
Mm-hmm.
And because of that safeguard, the New York Psychiatric Association actually signed on as a very strong supporter of the bill.
Yeah.
So that's important, I think, to know. Another thing that's important to know is that it's completely voluntary for anybody who might participate in this. So no doctor has to participate in this, no nurse, no pharmacist, and there's no penalty for not participating. So if somebody has a moral objection to doing this, they don't have to, they're protected. Another protection in the legislation is that if somebody chooses this, they cannot be denied life insurance payouts as a result. And that's also very common in other states. The one area where the New York State bill differs from a number of states, and many of the states where this is currently legal are also reconsidering this particular issue, is the issue of a waiting period. So when the law was first passed in Oregon, they created what they called sort of a cooling off period. A patient would have to ask for this orally, and then there would be a 15-day period where they would have to wait and then request it again orally, and then request it in writing before being able to get it. And that's pretty typical in most states. With 30 years of data, what researchers have found is that waiting period, because people typically avail themselves of this, very late in their course, that imposing that waiting period actually leads many people to die and suffer terribly while they're waiting. So the New York bill doesn't include the waiting period, but that doesn't mean it can happen quickly. It takes time, for two physicians to assess you, review your medical records, make sure that you're competent. All that work is not something that happens quickly. So there's still lots of time before somebody gets the actual prescription filled. And then once somebody gets the prescription is filled, the other thing we've learned from all these states is that somewhere between 30 and 40% of people who get the prescription never end up using it. But just having it is comfort. Provides tremendous comfort. Yeah.
Let me ask you two kind of in the weeds questions about the provisions that you just articulated. The first about the physicians needing to attest to the patient's prognosis, that they have less than 6 months to live. You and I both know that doctors are pretty bad at that. Right. I mean, there have been studies that have looked at people referred for hospice care, for instance. Doctors' predictions are not so good about how long people have to live.
It's true. It's true. It's very true. And I think what's really important, I think, for our listeners to know is that the typical scenario is that doctors overestimate the amount of time people have left rather than underestimate it. So this is why, as you and I know, and as we've watched hospice roll out across the country, people are referred for hospice incredibly late in their course. And the typical length of time people are on hospice is weeks. The benefit is really designed to support you in the last 6 months of life, not just for the last few weeks. So, big picture, doctors are typically not, prognosing patients as having 6 months to live when they really have much longer to live. Okay. It's typically the opposite.
What is the prescription?
So the prescription, it's changed over time. There's actually an academy of physicians who participate in medical aid in dying in other states that are constantly looking at the data associated with various regimens, how quickly they work, what's the average time to sedation, what's the average time to death. And so right now it's basically, I think, a 5-medication cocktail that a pharmacist compounds. So what that means is that the pharmacist takes all 5 of those medications and mixes them together into a powder form in a small bottle. And the actual process is that 2 to 4 ounces of water or apple juice are added to that little bottle. It's shaken vigorously, and then the patient, has to drink that down within a couple of minutes because they're going to fall asleep very quickly. And the idea is to not take part of the medication before they fall asleep and have it not work.
And presumably it's some combination of narcotics and benzodiazepines, other things that suppress respiration and make you sleepy?
Very much so. So there'll be some kind of narcotic or opiate like morphine in a very high dose, some kind of benzodiazepine like Ativan or Valium. Those are trade names, but I think people are familiar with them.
Yep.
And then those medications work very, very quickly. Patients very, very quickly enter into a very, very deep sleep. And then the other medications that are in there are designed to stop the heart from pumping, and that happens, once they're already deeply asleep.
So let me shift gears here a little bit now that we have a common understanding of the kind of nuts and bolts of this. You and I spoke a week or two ago in anticipation of this interview, and you told me that you thought that there was, in fact, kind of a deep irony in your involvement in this movement to allow physicians to assist patients in ending their own lives, because that was kind of anathema to what you were doing earlier in your career when you were providing care for people who were homebound and had advanced illness. So could you talk a little bit more about that?
So for the first 10 years of my career, I had co-founded and was running this program that you mentioned, the Mount Sinai Visiting Doctors Program. Patients were referred to us when they were homebound, and it was very, very difficult for them to get to the doctor. The types of patients who were in that category of being homebound typically were people with very late-stage illness. So we had people with advanced dementia. We had patients who had severe strokes that lived in, maybe a 5-story walk-up in New York City. And it was very difficult to get to the doctor. We took care of people with very late-stage heart failure and emphysema. We certainly took care of patients with very late-stage neurodegenerative diseases such as ALS or multiple sclerosis and the like. We started that program in East and Central Harlem. We were taking care of, folks who were from historically very under-resourced communities and very vulnerable. Two things were true at the same time. One was we had our concerns when we saw the law that was passed in Oregon, about whether or not there would be abuse or coercion, or people in vulnerable communities would feel like they had to choose this because they didn't have other options. And at the same time, we also had a number of patients who, despite having access to literally the world's best palliative and hospice care, were living and dying in agony. And because then, as now, there are patients for whom we do not have answers with regard to ameliorating their suffering. So we couldn't square the circle on those two realities because we didn't have any data. The law had just passed in Oregon, and it wasn't in New York, so it wasn't even a question. I remember I was taking care of this young woman who had metastatic pelvic cancer, and we couldn't control her pain in the home. We brought her into the hospital, and she was on our palliative care service. We couldn't control her pain in the hospital, and she was in absolute agony beyond measure, and she was dying, and she begged us for help in dying, and we certainly couldn't offer her any because it was illegal. We watched with a tremendous amount of interest and curiosity as the Oregon law was passed and as medical aid in dying spread to other states, to gain insight into whether any of our concerns about abuse or coercion or effects on vulnerable populations would bear out. In so many ways, I'm gratified that, New York didn't try to pass this law first because we wouldn't have had any of the data to look at. We're very fortunate that we've got 30 years of data to look at. And what we've learned from that is that all of those fears that we had have never come to pass. So, I think the American version of medical aid in dying is the right one. It's incredibly resilient. We've never seen any slippery slope. So, for example, in other countries, you'll see people qualifying who aren't terminal.
Yes.
Or people who are qualifying where the only illness that they have that's causing their suffering is a mental health illness. Or you'll see, as I've said, the doctors administering the medication. None of it holds here, and we've never seen any state even attempt to expand inclusion criteria for any of those populations.
So let me ask you a related question. Obviously, nobody wants to see somebody with a terminal illness suffer. But I want to challenge a little bit what you said about relief of suffering versus aid in dying. You and I both know that early in medical training, in medical school and in our postgraduate training, there's this sort of prime directive of do no harm. And so shouldn't we really just be trying harder to relieve suffering instead of helping people end their own lives?
Oh, it's such a great question, and it's one I think about all the time, get asked all the time. I think both things need to happen. We have to absolutely continue to work to expand access to palliative care and hospice care and advance the science of ameliorating suffering, because we know that we can prevent a tremendous amount of suffering if we do those things. At the same time, it is absolutely true that today, as was the case 30 years ago, there are people who will live and die in absolute agony despite access to the very best of those services. Yeah. And so we have two choices. We can either turn a blind eye to that suffering, or we can do the hard work of striking the right balance and create a viable option for them so that they have, a measure of control and potentially can avoid, interminable suffering. I do want to go back to your point about the oath that we take, because I think it's a really interesting one. So, the original Hippocratic Oath included that doctors should not participate in abortions. Back in the 1950s, the norm in healthcare was, when you surveyed physicians and asked them if you have a patient who has cancer, would you tell them that they have cancer? The vast majority of physicians said that they wouldn't. Yeah. The norm in our country was not even letting patients know that they had cancer. And so, we have evolving ideas about what a physician's responsibility is. Yeah. When we think about specifically the idea of do no harm, when we stand by and bear witness to somebody who is dying in agony and we have the means to help them, and they're a competent adult, and there's nothing we can do to save them or relieve them of their pain, and all they're asking for is the ability to die earlier. I think I've come down strongly on the side of us violating our oath in that case if we just stand by and allow that to happen. I also think there's been an absolute change in the zeitgeist. So at least in New York State, so as an example, the Medical Society of the State of New York, which you and I both know has typically been a very conservative organization and has had a very strong position against medical aid in dying. In the last year and a half, they flipped completely, and now they strongly support the legislation. There was an attempt to roll that back this year, so they did a revote. 80% of the delegates from across the state voted to support the legislation. So we're seeing physicians now, even physicians organizations that are historically conservative in our state, recognize that this is potentially part of a physician's duty rather than something they shouldn't do.
Yeah, so let me ask you a little bit more about the role of physicians in particular about this. Is there concern either on your part or in others who have looked at this that having doctors in particular participate in this could somehow erode public trust in who physicians are and what they do?
There was a lot of concern about that when Oregon first passed its law. I shared all of those concerns. So we have all these hypotheticals. I think, again, if we didn't have quarter century of robust evidence to examine, I think would be potentially valid hypotheticals. But when we actually look at the studies that have now been done in states where this law has passed and has been on the books for years, we know there's been no erosion of public trust in physicians whatsoever, even amongst the people who know that physicians are participating in this. And I think this applies to so many of the hypotheticals. There's the hypothetical and there's the evidence. Yes. And I'm so grateful that we have the evidence.
So we're obviously having a different conversation than we would have had 10 or 20 years ago as a consequence of that. Yeah. I want to turn back to the slippery slope question, because it seems to me that's really where people's discomfort with this sits. Simply put, there's a concern that even in these highly circumscribed or tightly controlled rules that govern how doctors approach this, that there's a sense that having doctors involved actively in a patient's death could lead to something more abhorrent, that, patients might feel pressured to end their lives because of financial burden or sort of expansion of criteria to include people who don't meet the circumstances. I'm sure you saw this piece that appeared in the New York Times just within the last week by Ross Douthat. Now, I'm just going to read the last two paragraphs of his column where he was very critical of the Medical Aid in Dying Act. Bear with me, it's just a couple of paragraphs. And so he writes, "That's why if you offer that option under supposedly restricted conditions, the restrictions may not hold. Suffering is general and not limited. The dying are not really a category unto themselves, and the case for a lethal solution will creep beyond the bounds yet set. In the end, you can have a consensus that suicide is intrinsically wrong, that suffering should be endured to whatever end, and that doctors shouldn't kill you. Or you can have an opening to death that will be narrow only at the start, and in the end, a wide gate through which many, many people will be herded." How do you respond to that?
Yeah, I really respect Rob, and I never miss his column, and he always challenges my thinking, which I'm grateful for. Christopher Hitchens used to say, that which can be asserted without evidence can be dismissed without evidence. And I could stop there, but I'm not going to because we have the evidence.
Yeah.
And the other thing I'll share is, Roth is a devout Catholic, and
Yes.
we most frequently hear that argument from the Catholic Church, although lay Catholics overwhelmingly support these laws. And what he doesn't say in the article is, I'm a Catholic and I cannot be for this.
Yeah.
And so I'm going to come up with a reason that I'm not for it without telling you that it's connected to my incredibly strong religious belief. So that's part of it. But getting back to the evidence piece, this is one of those cases where, we always hear when there's a new controversial bill, show me the evidence, and frequently there isn't any evidence. And then when there is evidence, people who are against it won't look at the evidence, so instead they'll turn to Canada or the Netherlands or Belgium or somewhere else. We have 3 decades of evidence in our own country. There is literally no slippery slope. It never expands. And one of the reasons that's the case is because the foundational legal principle in the U.S., as affirmed by the Supreme Court, is that Americans don't have a fundamental right to this. It has to be legislated. And that means the legislatures are the ones who decide if they want the slope to slip. Mm-hmm. And it never happens because Americans don't want it to. Canada has a completely different framework. Yes. Their Supreme Court tied it to their Charter of Rights. And so it's a completely different animal. I think opponents, and I have tremendous respect for people who think this isn't the right thing, have been searching desperately to find even one case in this country over 30 years of coercion and abuse and slipping of the slope, and they haven't been able to. The last point I want to make about that is patients right now have the autonomy to make all sorts of choices about withdrawing chemotherapy, stopping aggressive treatment, with having the ventilation that they need to live withdrawn. They have those rights right now, today. Yes. We don't force people to stay, on a ventilator. We don't force people to take chemotherapy, even if they decide, they've reached the point where they'd like to stop treatment. We think about this as so different than those things, I think, because it's just not something that we've grappled with in our state before. But in the states where it's legal, a very small percentage of people use it. It's part of a holistic medical system that includes patient choice, autonomy, bodily autonomy, palliative care, and hospice care. It provides a tremendous amount of relief of pain and suffering.
Yeah. Well, maybe we should leave it there. Jeremy, thank you so much.
Oh, of course. It's an honor to spend time with you, Ira, and I'm so happy to reconnect with you as well.
Best wishes to you on a more personal level, and thanks again for sharing your story and your advocacy on this important subject with us today.
I'm grateful for the opportunity.
Thanks also to our producer, Connor Pilkington, our audio engineer, John Mullen. For more information about this program and to find all of our past episodes, please visit our website at medicine.hofstra.edu/wellsaid. You can also subscribe to our free podcast wherever you get your podcasts. Our listeners are also welcome to send their comments, suggestions, and questions to wellsaid@hofstra.edu. Until next time, I'm Dr. Ira Nash, and that's Well Said.